G'day and welcome to another episode of Pellowe Talk. I'm Dave Pellowe and today I'm joined by Neil Foster. Neil is an associate professor at the University of Newcastle where he teaches predominantly law but also an elective in law and religion. Thank you for joining me today, Neil. How are you?
I'm very well, thank you, Dave, and it's a pleasure to be with you.
Now, I was interested in your article that you recently wrote talking about the new section of emergency legislation that was miraculously passed with bipartisan support, intended to provide emergency and temporary protection for people who might get their feelings hurt during this debate and discussion about redefining marriage. What can you tell us, basically summarize your article for us? What does that talk about?
Well, it is a significant piece of legislation, and it certainly caught many people by surprise, I think, the way that it so quickly went through Parliament with support. There are a couple of aspects to the legislation. I suppose part of the background is that in Australia for many years we've got used to advertisements at ordinary elections being accompanied by a little phrase at the end telling you who's authorised the statement. And we are not having an election, of course, with this postal survey. It's not even a plebiscite, but there's an attempt to apply those sorts of rules to this context. And so one of the provisions in the legislation requires authorisation of comments that reflect what's generally called marriage survey material. And there are a couple of other pieces of the legislation, one of which is to make it unlawful to vilify or intimidate or threaten to harm someone on the basis of their views about the plebiscite or the survey, or their views about the survey question. But then there's also an interesting thing which extends that to the vilification, intimidation or threatening to harm someone on the basis of either their religious conviction or their sexual orientation. So there's a couple of features of the legislation which are very interesting.
It seems to me, what's wrong with the current law framework that we have, that extra law needs to be brought in? Why is the current legislation not considered significant already? It's already illegal to defame somebody. It's already illegal to harass or make threats to people. And quite frankly, it's already the case that with regards to 18C, although that's based in racial vilification, there's no shortage of complaints and strenuous, stressful processes that people have to go through with regards to the discrimination tribunals that abound in every state. It's already really, really hard to express a strong opinion on homosexual marriage.
Well, I think there can be a legitimate debate about whether this legislation was necessary. As I've pointed out in my comment online, I think there are a number of problematic features of the legislation. I suppose the concerns that have been raised, though, are that with the heightened intensity of the debate over the issue and people now presented with a very stark choice of saying yes to same-sex marriage or no to same-sex marriage. The fear that has been put forward by some people is that this will generate intense animosity and discussion, and therefore there needs to be some limits put on it. So I'm personally not persuaded that it's entirely necessary. On the other hand, it's not quite as bad as some state-based legislation already is. I've expressed quite a bit of concern about the Tasmanian anti-discrimination legislation, one provision of that which really does make it unlawful to offend someone on the basis of sexual orientation, which I think, and most commentators I think and scholars have looked at this and think that that goes too far in terms of restricting free speech. So the bar in this legislation here in terms of vilification, threatening, intimidation, so it's reasonably high. I think that you would have to be expressing some pretty seriously harmful speech to be caught by the legislation. But one of the big problems about legislation like this is where the terms are a little bit ambiguous, a little bit unclear, and that in itself can have a chilling effect on people's willingness to say something.
That's right. And that's not good for democracy, is it? Like, like we have Senator Penny Wong expressing grave concerns with people questioning the science and the studies that suggest that the children of homosexual parents don't have as good outcomes as on average as the children raised with their biological married parents. Now, that's science and that's research, and you can have debate about studies with different outcomes, but Penny Wong seems to characterize people who pay any attention to that research that they're bigots and haters and somehow questioning her personal parenting ability, which I've never heard anybody say that a homosexual cannot be a good parent. They've only said the research suggests that where there's broken biological bonds, it's reasonable and consistent to predict that children will, on average, have not as good an outcome as where they don't.
Well, I think that that's generally correct. That it's a significant issue what you've raised, and as you say, what Senator Wong's raised are important sociological questions, which really should be debated, and should be debated openly, and the evidence weighed up clearly by people on both sides. And I think myself that the way that the legislation is framed, simply engaging in that debate, does not rise to the level of vilification. That at least is the way I think the legislation ought to be interpreted, because we do have a number of values in Australian law which inform the interpretation of legislation, and one of those clear values is free speech. So I think that there are reasons for a court, if a court was presented with a case under this legislation, to interpret the word vilification as rising well beyond a simple respectful debate about scientific studies and people's expression of their own opinion based on, for example, their religious beliefs.
Yep.
It would seem to me that those sorts of things ought not to rise to the level of vilification. And I think that on a proper reading of the legislation, that's the way the legislation ought to be interpreted. But as I said, one of the unfortunate features of it is that it does raise doubts in people's minds, and so it may discourage some people from choosing to enter into the conversation.
Yeah, that's a worthy thing to note is that chilling effect that this is likely to have on a lot of people, and that's not good for the robust democracy that surely we would all at least notionally say we want, where ideas are contested and debated and discussed and held up for examination. Good ideas and bad ideas all need to be heard in order to be identified one way or the other. So I'm happy to hear your confidence and perhaps even optimism that somebody like me in a commentariat role can express an opinion that's not based in any kind of prejudice or hate or vilification or difference of holding different people in different value, but actually just wanting to find the truth and the merits of the situation. What I fear for is those vast number of people who don't have the qualifications and the background and the knowledge that you have to give them that same confidence. That's got to have a negative impact on this debate, and that means that people are going to be making their decisions, casting their votes, and using their voice with less information than we would like them to have before making such an important decision.
Yes, I think I'd agree with that. I think that it's an unfortunate side effect of this legislation that it may restrict open, honest discussion on these issues. And I hope it doesn't. I hope that people are willing to express in a respectful way their views on these different matters. And none of us would support speech that's designed to threaten people, intimidate them, to put them in fear of suffering harm. Yeah. And indeed, it has to be said that we've seen some examples of that sort of speech in recent times, and it has to be said, yes, mostly from the no side of the case.
Yeah, very true.
So it's possible, and perhaps I am a sort of glass half full sort of person, but it's possible that the legislation may encourage some people who were planning to conduct themselves in that way to think again. So from that point of view, it will be useful. The other thing of pointing out is that it is very temporary legislation. It's designed to cut out on November the 15th.
Temporary.
At the latest.
Yeah.
Yes.
And I don't know if I trust that.
Well, the way our parliamentary system works is that if it were to be extended, and I don't think there's any justification for doing so, but if it were, then they would have to change the legislation through Parliament. And at the moment, I think there's probably not a lot of support for extending the legislation in the various parliamentary venues. And I would certainly not want to see this made a permanent feature of Australian society, because I think that these are radical restrictions on free speech, or they potentially are, and need serious parliamentary debate and serious examination of the consequences before they're extended any further. And in particular, I am a bit concerned about one of the provisions in Section 15, which is part of what we've been talking about, prohibiting vilification and intimidation and threatening, which is based simply on a person's religious beliefs or sexual orientation, and in effect imposing restrictions on free speech, which may be said to be based on these things, with no direct reference to the same-sex marriage issue or the same-sex marriage debate. So on the surface of that provision, as you read it, it operates irrespective of discussions about same-sex marriage and the plebiscite, or the survey, I'm sorry. So I'm very much concerned that not be something that just slips by. It seems to me that itself in particular is a matter of some concern, and it would need very careful consideration in the federal parliament before it went forward. And in fact, the other feature of it is, I think I've mentioned briefly, that one could doubt that if it was made a permanent feature, it would actually be constitutionally valid, because there are serious doubts about the power of the federal parliament to enact that sort of legislation.
I have to ask, why would it be constitutionally valid temporarily if it's not constitutionally valid permanently?
Well, that's a very good question, and academics will no doubt write articles about that. But my view is that if it's justified, and we may or may not ever discover whether it's constitutionally justified to have the current law, but if it is, it would be based on the fact that it's in the context of a proposal to change the marriage law, and it would be based on the marriage power, and it would be regarded as, well, it was just necessary to put this in temporarily while we had this discussion in the Australian community about this change to the marriage power.
That's the theory. I don't agree with that. I think that's ridiculous. It's like telling us all we're too immature and too irresponsible to be trusted with the freedom of speech. And that's condescending and patronising, and I resent that on behalf of all Australians, let alone myself. Like, come on, we are capable of a grown-up, mature conversation, and we are capable of shutting down those people who act like ferals when they do obstruct free speech, obstruct the freedom of association, and those kind of behaviours that we do see that being condemned, and all the predicted bile and vilification from the right has not at all manifested. I've got an inherent faith in the Australian population to have a mature conversation, and it's a shame that our politicians don't. Look, quick question. How do you and I, as bloggers, comply with this legislation? And does it affect every conversation on Facebook? Does somebody need to put a disclaimer if they're having a discussion on a political debate forum on Facebook? Where does this line get drawn?
So what we're talking about now is a different provision of the legislation, not the anti-vilification provision, but the authorisation provision, which is Section 6 of the legislation. Again, interpretation of this can be debated, but the view that it seems to me is the most plausible view of the law is this, that where there is a public comment that's made publicly available to people, that the authorisation provision requires the person who's responsible for that comment to include at the end a brief statement of who they are and what city they come from. That seems to be the import of the legislation at the moment under Section 6, subsection 5. And this is not only where the particular discussion directly urges a vote yes or a vote no, But also, as you read the legislation carefully, it seems to me that any discussion of the matter of same-sex marriage requires that sort of authorisation statement. So it's not a disclaimer, although I understand why you're referring to it that way, but it's an authorisation.
Sure, the authorisation, that we normally see on a call flute or a flyer. Does that need to go on a Facebook post if somebody says, hey, that's a silly meme? No, we're not talking about the value of people, we're talking about the unique definitions of an institution. Do they need to put disclaimer, David lives in Logan?
In my view, not, because the legislation uses provides a specific exemption from the authorisation provisions for what it calls personal conversations.
Okay.
Now, I think that most conversations just on a person's Facebook page would be regarded as personal conversations. And so I don't think the legislation would apply to general Facebook comments on these matters. Mm-hmm. Certainly one could say, and there may be distinctions to be drawn, but I would have thought it was certainly the case that if you have a Facebook page that is not public, that you would not need a disclaimer. And arguably, I think most other Facebook conversations are meant to be, as it were, personal conversations. Having said that, then I think if you step out into the realm of blogging, as you and I do, and intend lots of people to read your comments in the public, then it would be safest, to put it that way, to put an authorisation statement at the end. And I've started doing that, and I think one or two other people have started doing that already.
I've followed your lead. It's safe is good. It doesn't really hurt me to put that down the bottom, does it? Is there any requirements for certain font size or anything like that they specify with posters and normal election material?
Well, you've caught me by surprise on that one, Dave.
Let's just infer that we'll take that as a note for later, but maybe it just needs to be legible and reasonably sized.
Yes, there is a specific provision. There's some provisions under Section 6 for different requirements.
Really? Okay.
I have a vague recollection that printed documents may have something of that sort, but just off the top of my head, don't have it with me at the moment. Worth going and having a look about.
Well, I'll ask you a less specific question just to wrap it up. This is what Corey Bernardi calls 18C on steroids. So the government has gone from being a free speech advocate and perhaps thinking about getting rid of 18C to maybe we won't bother right now, to actually making it worse and reducing the freedom that we have to express ourselves politically in Australia, at least temporarily. What do you think about the suggestion of actually the necessity and space for some very specific defined legislation for protecting free speech, to actually perhaps undo some of the lawfare and the weaponisation of human rights anti-discrimination tribunals and human rights commissions that we've got in Australia? What scope do you think there is for that? Not so much the appetite, I can pretty much guess that, but as a law professor, do you think we need some free speech legislation to nut this out specifically once and for all?
It's a very interesting question. There has been, over the years, a discussion about introducing what's generally called a Bill of Rights, protection for human rights in Australia. And a number of people on the conservative side of politics and Christians have resisted that for different reasons, and mainly because the model that's been suggested in the past was one that gave quite a deal of power to courts to override parliamentary decision-making, which I think is wrong. And most of the commentators these days in Australia in the human rights area also agree is not a good idea. So, and that you may sound like I'm not answering your question, but I am coming to it.
No, not at all.
One way of protecting free speech would be to introduce some protections for the internationally recognised human rights under the International Covenant on Civil and Political Rights, for example, the ICCPR. That contains strong free speech protection. It also contains freedom of religion protection. And I think there's a debate that ought to be had. And in fact, no doubt Frank Brennan would say we had it already, and unfortunately Parliament didn't agree with the inquiry. But the inquiry that was held a few years ago suggested a model that I think was not an unreasonable model, where one would set up a prima facie presumption of compliance with certain human rights. that the courts would not be able to override parliamentary legislation, but make recommendations about possible changes to the law where they perceive that there was a problem with a breach of human rights. So that's one consideration that could be given. We need to step slowly here. We need to examine all implications carefully.
The last thing we want is another activist judiciary like they have in America, where a majority of one person on a panel of 7 can change and radically interpret the Constitution to redefine marriage on behalf of an unwilling nation and supersede the sovereignty of many of the states in that Commonwealth, in that federation.
I absolutely agree with you. We don't want that situation where judicial power can be used to override the parliamentary legislation in these areas. And most people in Australia these days, I think, who are suggesting increased human rights protections would also agree. But certainly, I think that's right. The model of the US, the model of Canada, which also has a history of judges on the Supreme Court of Canada overruling parliamentary decision making, I think is bad. But I think there is at least some consideration that ought to be given to, and even if we don't do the whole ICCPR, Australia might have the power to implement increased protection for free speech, increased protection for religious freedom based on some of those international provisions. And that's, I think, a debate that seriously ought to be had. We have at the moment some protection for free speech in Australia. There's an implied freedom of political communication under the Constitution. And that in itself would be a reason to challenge some of these provisions that are in force at the moment, if they were not temporary provisions. And indeed, as you say, there can be a difference of opinion as to whether, in fact, already they go a bit far in overriding free speech. But certainly if they were made long-term, if there was any suggestion that these things be continued, then I think there would be a good chance that they would be unconstitutional and declared to be so by the current High Court. So I think there are, having said that, it's unsatisfactory to rely on implied provision. It would be better for our Parliament to express a very strong preference for free speech and to implement that if at all possible. And I think that's a debate that ought to be had flowing from these sorts of matters.
There's so much more I'd like to talk to you about. We have a lot of common interests, but I will save them for another day. But I really can't wait to get you on again. It's been wonderful talking to you. Thank you for joining me today.
It's been my pleasure, Dave.
That's Neil Foster, an Associate Law Professor from Newcastle University, specialising in law and religion as well. And if you've got any questions about that, leave them beneath the video. I'll ask Neil if he can answer some of those. Obviously, we could go on forever with that, but generally, if you're just commenting on Facebook, you should be okay in a private conversation, and otherwise, I'll put a link to Neil's article explaining and giving advice on, generally, not directly and personally, about how we should and could interpret this law and comply with it to just be safe. And if you'd like to help sponsor the next episode of Pellowe Talk, then please head to my website, churchandstate.com.au, and you'll be able to see recent articles, interviews, as well as the links to partner and donate with everything there. But that's it for today. Thank you for watching, and look forward to reading and engaging with your comments beneath the video. Bye-bye.